The first thing that must be understood about criminal liability is that it concerns itself with legal duties to act rather than moral duties to act. In other words, something is not against the law unless the law says it is. The statute that someone violates must be an act of law at the time the offense occurred. In addition, the law that is violated must carry with it some sort of punishment for violation. Now, that punishment can be either a fine or a jail term or both. Hello and welcome to the PSTN Basic Security Officer Training Series. I'm Bill Jackson. Every crime carries with it certain elements that define exactly what that crime is. The best way to define what an element is would be to think of it as an ingredient to a recipe. If you leave portions out of a recipe, you will not end up with the dish you started out to make. It's the same way with a crime. The elements all have to be there that combine together to make a particular offense. The elements that are common to all crimes are as follows. First, a voluntary act or omission. This is called the actus reus and refers to the actual thing that was done that violates the law. It's important to note that the act must be voluntary. It must be an act committed by someone of their own free will. More about this in a little while. Number two, a guilty state of mind. It is sometimes referred to as intent. The law calls it mens rea. It's a state of mind in which the perpetrator of the crime intends for the criminal act to happen. Number three, actus reus and mens rea must work together to create an act that is a violation of a statute. As you can see, there is more to committing a crime than just going out and doing something wrong. Sometimes it's easier to understand when the elements are broken down into what is called the 7 principles of crime. Number 1, legality. There must be a violation of a current law. Repealed laws don't count, nor do laws that have not yet taken effect. Number 2, actus reus. There must be bad behavior, not just bad thoughts. The behavior can be one of commission or omission. You can think all the bad things that you want, but until you engage in an act in furtherance towards the commission of the crime, it doesn't count. In other words, you can sit down and plan out a robbery to the last detail, but until you go out and attempt to steal a getaway car, you have not committed a crime. 3, causation. There must be a relationship between the act and the intent. If you plan a robbery and then forget about it and then steal a car a year later, there is no connection to the robbery. Car theft, yes. Robbery, no. 4, harm. There must be an impact on some legally protected value. You can't be charged with trespassing on your own property. There is no legally protected value in the charge. 5, concurrence. The intention and the act must go together. The evidence is usually used to show that the defendant in a criminal trial intended to cause the harm that resulted from the commission of the crime. 6, mens rea. There must be a guilty state of mind at the time the act occurs. In other words, there must have been intent. 7 is punishment. There must be a sanction applied for the violation of the law. The punishment for the crime can be a jail term, prison term, and/or a fine. So when you put all of this together, you come up with a definition of crime that looks something like this. Legally prescribed or prohibited human conduct causative of a given harm, which conduct coincides with a blameworthy state of mind and which is subject to punishment. These things, when taken as a whole, show us why it is sometimes so difficult for the state to prove that a crime was committed by a certain person. In a criminal case, the burden of proof rests with the state. In other words, the state must use the evidence that is available to prove to a judge or a jury that the person on trial committed a crime. Furthermore, they must prove the case beyond a reasonable doubt. All 7 principles must be established in court. The defendant does not have to prove himself innocent. It is the responsibility of the state to prove them guilty. The defendant does not even have to testify if he doesn't want to. By taking a look at the listing of the 7 principles, it's easy to pick out the one that the state is going to have the most trouble proving. The first 5 principles can be established by the evidence. Number 7 is a given, or the case would not have made it to trial. The state's biggest hurdle to overcome is number 6, the guilty state of mind, otherwise known as intent. As a security professional, you must understand why the burden is so heavy on the state. It was established that way in the interest of justice. The state, after all, is the government entity that controls the police, the detectives, the crime lab, the prosecutor, the courts, the jails, and the prisons. In other words, the whole criminal justice system. The defendant can only rely on the skills of his attorney and the due process requirements of the system. As professionals, we must also be keenly aware of our obligation to use the system the way that it is intended to be used. Our dealings with the court system must be of the highest integrity and utmost truthfulness. Anything less will weaken the system and dishonor the profession. So, why is intent so difficult to establish? The reason is simple. The body of law that has been built up by our civilized society has established many ways for people to go to court and say, yes, I did it, but. The yes, but defenses are properly referred to as affirmative defenses. In an affirmative defense, the defendant is not saying that they didn't do something. They're saying to the court that there is a reason why things turned out the way that they did, and the reason usually has to do with things beyond the direct control of the person on trial. Also keep in mind that the defendant is not required by law to establish their innocence. They must only create a reasonable doubt in the minds of the jury or the judge. So, what kinds of criminal charges cause the most common problems for security practitioners? As you might expect, the list consists of those types of criminal acts that involved a direct interaction with another person. Here's a listing and a brief description of the kinds of offenses that people in our business face the most. Bear in mind that statutes in each state vary. To find out about your state statutes, log on to looseleaflaw.com. You'll find all 50 states on this website. Now, let's discuss the offenses. The first one is assault, placing another person in the reasonable fear of being battered. Battery, actual physical contact of a hurtful or insulting nature. Next, manslaughter, the unlawful taking of a human life without premeditation or intent to kill. Murder, premeditated intentional taking of a human life. Burglary, the unlawful entry onto the property of another with the intent to commit thereon a crime, usually a theft. Trespass, the unlawful intrusion or the unlawful staying on the property of another after being given notice to depart. Criminal defamation, starting a rumor that someone is a convicted criminal. Generally, this is a tort action, but it may be a crime in some jurisdictions. False arrest, taking someone into custody without legal authority to detain. It's also known as unlawful restraint. Unlawful possession of weapons. Possession and/or display of a weapon is defined by statute. Prohibitive offense of weapons is the title in some states. Disorderly conduct. doing anything in such an unreasonable manner as to alarm and disturb another person and provoke a breach of the peace. Robbery, an event committed by force against the victim's will in the presence of the victim. The perpetrator can either be armed or unarmed. Extortion, theft through the implied use of force or terrorism. Eavesdropping, intentionally monitoring the presumed private conversations of another person. Theft, the taking or possession of the property of another with the intent to deprive the owner of the property with its use or benefit. Retail theft, theft committed in a retail establishment such as shoplifting. Perjury, lying or giving false testimony under oath. Subordination of perjury, inducing another to commit perjury. Misprison, failure to report a criminal act or failure to take obvious steps to prevent violence. Compounding a felony, receiving or offering money for a promise not to prosecute or aid in the prosecution of an offender. Conspiracy, planning a criminal act and then committing an act in furtherance of its commission. Now, for more information about state criminal codes, check out this website, gouldlaw.com. Just how are you to protect yourself from criminal charges? Simply stated, know the law and avoid crime-producing circumstances. Once again, this is a perfect application of the same simple guidelines that apply in avoiding civil actions. 1. Act and react in a reasonable manner. 2. Know and comply with your post orders. 3. Understand and operate within the confines of your job description. Remember, if you do your job the way you're supposed to, and if you conduct yourself in a reasonable manner, and if you are careful to document the things that you see, hear, and do, you should be fine. As a security officer, you do not, under normal circumstances, have the same kind of legal authority as a police officer. If you think back to the list of criminal offenses, you can see how this relates to the discussion. A number of the criminal problems faced by security officers involve physical contact with a citizen that goes beyond the authority that the security officer has. Basically, the biggest difference between a security officer and a police officer involves two things that the police can do that we cannot. First, the police may make an arrest on view or on a warrant on behalf of the state in order to bring a citizen before a judge to answer to a criminal charge. Second, the police may use physical force up to and including deadly force in order to accomplish the first objective. Now, in a free society, this is a considerable amount of power. That's why it's subject to such close scrutiny and so many laws and regulations in the way that it's used. Along with the power comes the responsibility to use it properly. Police authority comes from the state. Security authority comes from the officer's employer or the client being served. The police may use overpowering force to take someone into custody and protect other citizens. Security officers can only use neutralizing force to protect themselves and others. Police officers are the agents of the state. Security officers are agents of the company or client that employs them. It is oftentimes noted that security officers have the same authority as private citizens, and this is true. But we must remember that we all have the authority of a private citizen, and that is more than enough to do the job. Since we are not police officers, we do not have the restrictions under law that police officers do either. What this requires of you as a professional is a thorough understanding of what is expected of you by the organization or the client. You will find this information in the rules and regulations. Your authority will be clearly outlined there. As long as you stay within the limits of your rules and your job description, you should have very little to be concerned about with regard to criminal liability. Experience will also show you that authority is a relative thing. With all the authority that a police officer has, they cannot confront a citizen unless they have enough proof of possible criminal activity to justify the stop. We, however, can talk to anyone we want to about the rules and regulations of the job site. Someone arrested for theft by the police might be found guilty and might face some jail time. Truthfully, they will probably get a small fine and never see the inside of the jail. If we catch someone stealing at work, they could face the loss of their job, their benefit package, and even their retirement program. That's in addition to the criminal charges. So, as you can see, authority is relative. Much of what we do involves the protection of the property that our client or company owns or controls. Both the common law and the statutes recognize the rights of the property owner to control the access to, the use of, and the activities on their property. That is what protection is all about. We are the ones charged by the organization with that task. Anyone who enters the property with the intent to do something contrary to the owner's wishes can face the criminal charge of trespass. Now, in general, the following conditions must be present for a charge of trespass to stick in court. First, the person charged must not own or have any legal rights to the property. Next, the person charged must be aware of the first condition. The person charged must not have permission of the property owner or agent, including the security officer, to enter upon or remain on the property. The property is posted in accordance with local laws with signs that prohibit trespass. The property owner or agent has requested the person to leave the property. The person charged must enter or remain on the property after seeing the notices or the barriers, or after having been given a lawful request to leave. Check your local statutes to make sure what the elements of the offense of trespassing are for your area. That is the standard that you will have to meet in order to prevail in criminal court. In the eyes of the law, the elements of what constitutes an arrest is pretty common across most jurisdictions. Once again, this is a subject matter area that you need to clarify with your local laws and local authorities before you engage in any of your professional duties. However, generally the elements of an arrest look something like this. The person making the arrest must have the intent to deprive the person being arrested of freedom of movement. This does not necessarily mean using handcuffs or physical force. It only requires that the arrested person reasonably believes that they are no longer free to leave or move about. The person making the arrest must communicate clearly their intent to the person being arrested. In most jurisdictions, the reason for the arrest must be stated clearly as well. The person making the arrest usually has to clarify their intent by making some action to back up the verbal notification. That can be as simple as pointing at the person or touching them on the arm, and could potentially involve actual physical force. The person making the arrest must surrender the arrested person to a peace officer or an officer of the court as soon as possible. Once again, check state statutes, county ordinances, and local ordinances to be sure of your status and your requirements under the law before assuming your duties. As stated earlier, police can use overpowering force. Security officers and citizens can use neutralizing force. In other words, once you have succeeded in negating the force being directed at you, the law requires you to back away and stop using force as an option. The only exception would be a situation where you are reasonable in feeling that your life or someone else's was in danger unless you acted in a more forceful way. Regardless of the situation, force should only be used as an absolute last resort and only when all other methods have failed or clearly would not have worked under the circumstances. Please understand that any time force is used by a security officer, there is going to be a lengthy and very thorough investigation of the incident by the organization and the local police. This is as it should be. The use of force is a serious matter and should never be taken lightly. Every citizen has the right to protect themselves from harm or attack, but please keep in mind that security officers are authority figures and therefore are going to be held to a higher standard than the average citizen. It may not be fair, but that's the reality of the situation. After a use of force incident, 4 major questions will be reviewed in the investigation process that follows. 1. Did the aggressor have the ability to harm the officer? 2. Was the officer in imminent jeopardy of being harmed? 3. Did the aggressor exhibit intent to harm the officer? 4. Was the officer precluded from escape or other defensive or control actions so that responding with force was the only option? No matter what the justification, you should know that the use of physical force to protect property is going to cause you problems. The courts take a dim view of force being used to protect anything but people. If you act in a reasonable manner, stay within your job description, follow policies and rules and regulations, and stay within the limits and abilities of your training, you should not have much to worry about. Just be sure to take the time to do your homework on the local laws. It could save you from problems in the long run. That's our program on criminal law and criminal liability. Thank you for joining us. We'll see you next time on PSTN.